Good afternoon. My name is David Leopold, and I'm a partner here at Thompson Hine in the immigration practice, which is part of the Labor and Employment Group. Today, we're going to welcome you to today's webinar. We're going to be discussing developments in healthcare law and in immigration law, those developments that directly impact employers, including regulatory compliance and risk concerns. So today, a couple of housekeeping items before we begin. We're recording the program, and a link is going to be sent to the participants and the attendees in the next few days. We've got a holiday, so it may take a couple days longer. The thoughts and the opinions being expressed here today are solely of the presenters. They are not representative of the opinions of Thompson Hine, of its employees, of its affiliates, and the content today should not be taken as legal advice. It is purely for informational purposes. Please feel free to submit questions. We will try to answer as many of them as we can while we're on the program. Feel free to submit your questions. In the related content section, you can download the PowerPoint slides and the speaker bios. So today I'm joined by my colleague, Labor and Employment Counsel, Jessica MacKeigan, here in our Cleveland office. And thank you for your interest. I will now begin the program and we'll kick things off. Thank you. Okay, so I'm going to start off with the immigration portion of this presentation and focusing on some of the enforcement issues that have come up since the inauguration back in January of 2025. One of the first things that happened on day one of the inauguration was a retraction of what we call the sensitive locations memo. And this directly affects employers in the healthcare industry because of search and seizure rules, which I'll explain. So what did the sensitive locations memo do? What it was a memorandum that went through various administrations, both Republican and Democrat, so it was bipartisan, and it went back several decades. And what that said was there were sensitive locations that Immigration and Customs Enforcement would not enter without the express approval of immigration headquarters in Washington, ICE, Immigration and Customs headquarters in Washington. So there was a chain of command that had to be followed before agents could execute any kind of a warrant on a sensitive location. They had to go up the chain of command and get permission from ICE headquarters. What kind of locations were these? These included churches. These included hospitals, healthcare systems, universities, religious institutions, synagogues, churches, mosques, etc. Anywhere that was considered sensitive. And what that meant was, of course, that ICE had to go up through a chain of command to go into any of those locations. So what we would find, of course, what was the practical effect? Well, it meant that if ICE was searching for, had a warrant for a non-citizen who was undocumented, allegedly being treated in a hospital, before ICE could go in and execute that warrant, they had to get permission from Washington. So it made it much more difficult. And you may have heard during Trump 1, first term, of individuals who had hidden out, say, in a church or in a synagogue or in a mosque, and that immigration would not go into those places. That ended on January 20th, 2025, when this locations memo was withdrawn. And that meant that all of these locations, including healthcare institutions, are fair game for enforcement without any kind of preliminary review by Washington. So what is the effect of this? The effect of this for healthcare institutions, of course, is a decline in patient trust. Patients are much more worried about being the subject of an enforcement action when they're in a clinic or in a hospital than they were before. What does that lead to? That leads to an avoidance of treatment. So you've got women who are pregnant, women who need prenatal care, other undocumented individuals, or even individuals who are documented but concerned about their immigration status because of, say, skin color or appearance, are much more reluctant to go into a sensitive location such as a healthcare institution. can also lead to operational disruptions while institutions and healthcare institutions navigate the complexities of what this means for them. We'll get into that a little bit more in a couple of minutes, but bottom line being that if there's a danger of immigration enforcement in a hospital or in a clinic, how do we prepare for that? So that leads to complexities in delivery of care. And a requirement, effectively, that healthcare institutions start thinking about enforcement protocols at premises. What do we do, for example, if ICE is at the door? What is the reaction? How do we prepare ourselves? How do we make sure that we are guarding not only the healthcare institutions' rights of our physicians, the rights of our caregivers, the rights of our researchers, also the rights, of course, mainly of our patients. So we will talk about that a bit as we move on. All right, so bottom line, what do we do? What do we do if ICE is at the door coming into a healthcare institution? If the agents show up, they could show up in plain clothes. They could show up, as we've seen in many viral videos of the enforcement actions in places like Los Angeles and in places like Minnesota, where we saw full Army gear, full military garbed enforcement agents coming into the streets and coming into institutions such as restaurants. What happens if this happens at a healthcare institutions? So does the healthcare institution have an existing, where do we start? Do you have an existing law enforcement protocol? What is your standard policy, for example, if an FBI agent or a police officer comes looking for a patient? This should mirror what you will want to do in the enforcement side. The difference, of course, is that in the immigration enforcement context, in most situations, not all, but most situations, the subject is going to be a civil enforcement, not a criminal enforcement. That said, there's not much of a difference in terms of the rights of the institution and the rights of the individual. The protocol should therefore be very similar to the standard law enforcement protocol, with a couple of important tweaks and differences that really should protect in the immigration enforcement context. First and foremost, in any protocol, you're going to want to designate an immigration liaison. Why is that? Well, whether it's a clinic, a small clinic, or whether it's a large institution, the key here is that consent to enter the non-public areas, such as where the patients are either being examined or the patients are being housed, such as the rooms. We do not want to give consent without informed consent, meaning ultimately the question of whether an immigration enforcement agent gets past the receptionist should be decided with the advice of counsel, whether it's the general counsel of the healthcare institution, outside counsel, somebody who can look at whatever paper, whatever warrant, whatever administrative warrant ICE comes in with, to make sure that all legal issues have been reviewed. Is the warrant sufficient? Is it a judicial warrant? Does it properly designate time and place? Does it have the legal authority to allow that agent to proceed past the receptionist, and search or arrest as the agent says that they want to do? Ultimately, as I said, these are issues that you're going to want to have reviewed by your general counsel or your outside legal counsel to make sure that the immigration agents are operating within the bounds of the law, and specifically within the bounds, the ambit of the Fourth Amendment, which protects against unreasonable searches and seizures. Okay, we also have to think in terms of HIPAA and the cooperation and violation or protection of HIPAA. So the hospital has no affirmative obligation to report a patient's immigration status. This is not similar to the I-9 employment verification context, where you have to keep records of an employee's and new employees' immigration uh, authority to work in the United States, employment verification. That's the I-9 process that begins at the beginning of employment. That does not apply to a patient. There's no affirmative obligation to ask a patient for their immigration status. Of course, HIPAA generally prohibits the disclosure of personal health information, PHI, without the consent of the patient, except as required by law, say judicial ruling or a court order. There are exceptions which allow for the sharing of certain information, but it's not necessarily required, and it can vary state by state. So it's important to check state law in terms of requirements to disclose information to a law enforcement agent upon request. All right, so we want to look to the regulations, but the regulations in this context, in the context of an ICE investigation as it relates to HIPAA, do not provide us much guidance. And certainly the Health and Human Services regulations have provided no guidance, and there's been no updated guidance, as far as we know, since the inauguration last year and since the removal of the sensitive locations protections or quasi-protections, because ultimately they could come on premises. They just had to go through ICE had to go through a protocol, which they do not have to do now. So unfortunately, there is no HHS guidance on this as it relates to HIPAA. So there are some analogous places to look. That would be the most important one would be the media, and what are the HIPAA obligations as it relates to disclosure to the media. So, for example, you cannot invite media into treatment areas or in any area of the hospital where personal health information may be accessible without written authorization from each individual. Again, applying that by analogy in the immigration context. The best result is not to have that HIPAA information available. So, for example, if an ICE agent comes into a reception area, meets the receptionist coming in, consoles on the computer could have information that's available to the eye, that's in plain view. That could be a disclosure of information, which violates HIPAA. So it's important to keep these things in mind as you're setting up the internal clinic or the hospital to prevent against disclosure of protected information. And it also is important to remember that there are limits to what ICE can do, which I'll talk about more specifically as we move forward here. Of course, a court order, a judicial warrant, a grand jury subpoena changes the ballgame. But as I'll point out in a few minutes, that's not always the situation when ICE shows up on location. Okay, so how do we start here? How do we start to protect ourselves? Well, first and foremost, generally speaking, ICE cannot enter a non-public area of an institution, whether it's a hospital or whether it's a standard business or whether it's a clinic or anywhere else, without a judicial warrant. So we need to designate what is public and what is not public. Common sense is one way to go. Actual signage is another way to go. So if I walk in, for example, to an urgent care facility anywhere in the city, just an urgent care facility, I know that I go up to the receptionist, I give my name, receptionist tells me to wait for a physician or for a healthcare provider to see me. I cannot go through the door unless I'm invited. If I do go through that door, if I simply go up and open the door of the waiting room, I'm probably, at least at the outset, going to be politely told to wait in the waiting room until I'm called. That's standard procedure, and then I go into the next waiting room. Now, that is a public area. ICE can walk into the lobby there just like I did, and they can start asking questions of that receptionist. And one of the questions that they can ask is, do you mind if we just go in and take a look for this person or take a look around? Now, if that receptionist says yes, you've got consent. It's done. There's no, the legal Fourth Amendment issue of protection of privacy is gone now because you've had somebody consent at the front. We can get into legal arguments later as to whether this individual, the receptionist, had the right to consent on behalf of the institution. But the problem is that now ICE has gone in. So that's where we start with the protocols. That individual should be instructed under most protocols that they don't have the ability to consent or to not consent. And the correct response to ICE, regardless of what paper they have in their hand, is I need to elevate this to my supervisor. I am not permitted to make decisions based on these, on the paper that you've given me. So could you please hold? And then move it up to the chain of command. Importantly, if possible, make sure that the doors are marked private. If that's not feasible or that's uncomfortable, just make sure you could obviously make sure that they're locked. Sometimes some of these doors have access only cards or codes. The more private you can make, objectively private you can make an area, the more clear it is that it's covered by the Fourth Amendment, that people need a warrant, that law enforcement needs a warrant to go beyond that door. Now, generally speaking, as I said, the lobby is going to be public, the waiting areas, and this is whether it's a small institution, small clinic, or whether it's a large hospital. Any area where the public can go in is not going to be covered by the warrant requirement because they can go right into there. So signage, public, non-public, where possible. Academic institutions, for example, going into a dorm always comes up. Similarly, if I can't go into a dorm unless I have a key card, that area is not private. I am likely going, as a law enforcement agent, I'm likely going to need a warrant to get beyond that door. So the same applies in the hospital setting. What are warrants and what are consent? Okay, this is an important issue in these days because of the way Immigration and Customs Enforcement has typically operated. Typically, what will happen, and this is in the home setting, and most of our experience goes before the change of administration, because most of the time that ICE showed up without a warrant was at homes, where they were arresting an individual out of their home, usually early in the morning. And what they would do is and they still do it, they would come in, knock on the door, say, "We're the police, please open up." The individual would typically open up. Once they open up, now we don't need a warrant if they're invited in the house or if they consent to coming in the house. What they do need to go in that house or to go into your clinic or to go beyond the waiting rooms, beyond the public areas, is a judicial warrant. That is a warrant signed by a magistrate or a judge, and it will have the name of the court on there. It will have the name of the proceeding on there. It will be signed by an independent judge. It will not be signed by a law enforcement agent. What ICE will typically show up with and tell your receptionist or tell your liaison person that this is a warrant is what they call an administrative warrant. How do we know it's an administrative warrant? It's signed by a law enforcement agent. It's signed by an ICE agent. And at the top of the warrant, it'll say Department of Homeland Security. The bottom of the warrant, it'll be signed by a law enforcement officer, not a judge. That's going to require training in most cases. So it's really important that if you're going to go this route, and you should, to make sure that your first line contact is trained at least superficially in what might be an administrative warrant versus a judicial warrant. And more importantly, that decision as to what that piece of paper is should be elevated up the chain of command, up the chain of authority, hopefully to counsel, so that the validity of that piece of paper can be analyzed quickly. What they do need to show up with, if they're going to go on beyond the public areas, into the private areas of the hospital, into the area of the hospital where the patients are being treated or housed, they're going to need a judicial warrant. And that judicial warrant has to comply with the same requirements that any judicial warrant in any context must have. Time and place, address, specific address, person or things to be seized, specifically designated. Therefore, you are going to need, it's important to have a lawyer at some point look at this to make sure that there aren't defects in the warrant itself. So If it's an administrative warrant and it's determined that this is an administrative warrant, the answer, if you do not want to consent to the search, is to politely tell the agent that we do not consent, please leave. Or please, or we're not going to go into the private areas. They can sit in the lobby all they want, but they can't go into the private areas. If it's a judicial warrant, and if it's proper, they can execute it within the bounds of the warrant. They can't go in for a free-for-all, but they can go in within the bounds of the warrant. Again, importantly, it's important that there be an internal protocol, that training of mid-level folks, people who are going to be making mid-level decisions, people who can elevate legal questions, understand what's going on. Because once we get into, oh yeah, no problem, you can go look in this patient's room, not only is that patient's room been consented to, but the whole ward, the whole area, the whole hallway, and they can just go from one place to the other. All right. So training and understanding of what they're presenting is important. And they typically will use administrative warrants. Why? Because it takes time to go to a judge and to show probable cause for the arrest and to get a judge to sign an order. It is much easier to type out an administrative warrant on an office computer and print it out and then go to the scene. The judicial warrant can take several hours. More than that, the administrative warrant is done in a matter of minutes. Okay, this slide you can look at if you want in a little bit more detail. It's a little bit more in the weeds in terms of what the difference is between the two, what the validity of a judicial warrant must have, and what the immigration warrant or administrative warrant has. Remembering, an administrative warrant does not require compliance. Even though it says, hey, we can go into this room and search for that, no, you don't have to comply with it. A judicial warrant is quite different. Now, in any circumstance, it's always important, if you do not want to consent, to have the expression of the objection expressed. Why? Because if they go in even on a judicial warrant and you've objected to it and you've continued to object to it, if there is a legal challenge to it later, that objection is a matter of record and can be raised with the judge. If something that's taken should not have been taken, if something that's seen should not have been part of the record, you can raise it with the judge. So it's important to make sure you've got all this planned out, how you want to proceed in advance. Now, ICE itself has said that they don't believe that they need to get judicial warrants. Now, the logic there, my humble opinion, is a little bit twisted. The logic is that if they're going after a non-citizen who is, in their opinion, under a final order of deportation or undocumented, then that person, that fact in and of itself constitutes a flight risk. If that constitutes a flight risk, then anytime they do this, anytime they search and seize, they're doing it in hot pursuit, and therefore the warrant requirement is not required. It's an exception to the warrant requirement. Somewhat akin to looking at a bank robber running out of a bank and going into a private home. You generally go after that person without a warrant. That's the analogy. That needs to be ironed out by the courts. Under the new immigration czar, a guy named Tom Holman, they're indicating that they are following the warrant requirement, at least in the business context. It's not clear. At least in the home context, they don't appear to be. So that one is a little bit gray. Multiple news stories indicate that they're still using this policy in the field of not getting judicial warrants and acting on only administrative warrants. This is going to have to play itself out in the courts in time. Okay. Again, summarizing, we want to be careful what's in public view in the common area, HIPAA information, other information, because that you don't need a warrant for. If it's in public view, it can be seen, it's fair game. You don't need to collect immigration status information from patients. You don't need to ask that question. You can provide educational materials in your lobbies if that's comfortable. That would help people understand what their rights are. There's a bunch of know your rights materials that are available online in 16, 17 different languages that are downloadable from all different kinds of groups. All you'd have to do is Google know your rights information multi-language. You'll get a whole bunch of information that can be put in your lobby. If that's not comfortable, you can provide it to people who ask for it. Obviously, if you it would be helpful to make sure that the protocol, what you're going to do, is in place. That should be done with the assistance of counsel. And importantly, designating an immigration or a law enforcement, however you want to term it, liaison. Clearly, hospitals, healthcare institutions want to be part of protecting the country, protecting the borders, protecting safety. This is not about hiding from immigration, and this is not about hiding people who should be arrested. This is about the dignity of the institution. This is about the dignity of the patients. This is about the dignity of your staff. So it's really about protecting rights. And so not consenting is not obstructing. Not consenting is simply expressing an objection to what's being done. And the importance of that is so that later on, if there's an issue, there's no argument that, oh, well, wait a minute, they consented to the search. They consented to the agents going in to the beyond the waiting rooms or into the hospital corridors that were not public or even into an operating room. Okay, so I'm going to turn it over to you, Jessica.
Thank you, David. I do have a question for you on your material. So ICE agents often come in and they'll be wearing body cams. Have you seen any guidance or rights, discussion of rights of hospitals in particular to ask them to turn those off? Because we know that staff aren't allowed to use cameras, for instance.
There's very little guidance on it, very little guidance on that in particular, but I see no reason why that they should be told and instructed, even in the context of a judicial warrant, to turn off body cams, because that goes beyond what is in the warrant, assuming the warrant, reading the warrant, but objecting. And if they don't turn it off, and likelihood is they won't, make sure that objection to the body cam, that objection to the intrusion is clearly stated on the record and recorded. And importantly, your question raises a really important point, and that's that regardless of what happens, your liaison, your hospital liaison, or whoever is responsible should write down what happened as soon as possible, record it as soon as possible after what happened. Why? Because the recency of memory and then jotting it down and making sure that it's part of the record can be very useful later.
Great, thank you.
Sure.
So thank you, David. I'm going to be talking briefly about some hot topics in employment law. I'll be discussing changes in state law and some perennial issues that impact the healthcare industry and its employers. I'll also outline some practical takeaways that you can use to remain compliant in this rapidly changing legal and regulatory environment. First up, non-competes. As many of you already know, states across the United States have banned or severely limited physician non-competes. Well, the big picture is that a significant number of states have moved aggressively to further ban these or limit non-compete agreements beyond just physicians, but to include a host of other providers within the ambit of those restrictions. Some of the most notable new entries into this space would be Texas, effective in September of this year. This is a good example of the trend. It's going to cap non-competes for certain healthcare providers, which is going to include physicians, dentists, nurses, and physician's assistants. At 1 year of duration and 5 miles within the geographic area of the place of employment. It will also require that physicians be provided access to their patient lists and that they can contact those patients to advise them of where they've moved their practice. The new law in Texas will also require that covered employees be granted the ability to buy out their non-competes for not more than 1 year of their salary. Finally, this new law in Texas will prohibit the enforcement of a non-compete against a covered employee unless the employee is termed for good cause. And what that means under their state law would be conduct that's directly related to poor job performance. Maybe it's a breach of contract or other employment agreements with the physician. The Texas law will not apply retroactively. Some other states that have gone on to add non-compete bans for physicians and other healthcare allied professionals would be Arkansas. Their law is a complete prohibition with no exceptions or carve-outs. Colorado recently expanded its ban to include not only physicians, but physicians' assistants, dentists, midwives, and advanced practice nurses. And this would be regardless if they meet the highly compensated employee threshold, which was at the original measurement for when you could have a non-compete with these individuals. Indiana likewise has expanded its restriction to include any physician hospital agreement, and this would bar not only non-competes, but training repayment obligations, which I'm going to talk about a little bit more on the next slide. And those things would not be enforceable until a physician has been employed with the entity for 3 years. Significantly there in Indiana too, employers also cannot require a physician to obtain consent for new employment or submit to equitable relief. This statute makes exceptions for confidentiality, employee non-solicits, and contracts in connection with the sale of a business. We've also had expansions in Montana, expanding its statute to cover a broad range of behavioral health providers in addition to physicians. Those would include psychiatrists, naturopaths, social workers, counselors, etc., family therapists. They have exceptions there that would allow TRAPS, which is a training repayment agreement provision, for repayments of loans and relocation costs, signing bonuses, and educational expenses. Finally, Utah has entered the fray and now has a new law that voids non-compete for all healthcare workers and prohibits non-solicits that prohibit the practitioners from informing their patients of their current or future place of employment. So the key takeaways here with all this activity at the state level is that this trend in non-compete restriction is accelerating, and whether it's outright bans or narrowing the geographic or temporal limits, the coverage is expanding beyond physicians to nurses and, as I said, other allied health professionals. So if you are currently operating in multiple states, you cannot assume that your agreement is effective in all of those states or even enforceable. It may even be subject to penalties if you have contracts in those states that violate the bans. So assume the most restrictive standard applies and audit your agreements according to that standard to increase the ability that you'll be able to enforce those agreements. Turning to a special form of non-compete, we often see these in the healthcare sphere. A training repayment agreement provision, commonly known as a TRAP, is an agreement where the employer pays for an employee to receive certain work-related training, education, and or other expenses related with obtaining employment with the employer in exchange for the employee's continued employment for a designated period of time. Now, with these agreements, what happens is that if the employee does not stay, they are obligated to repay all or some of these expenses if they leave before the end of the specified term. So TRAPs therefore serve both as a retention device and a clawback or repayment mechanism for employers to recoup certain expenditures that they've made in bringing this employee on board. However, at the state level, TRAPs are facing significant legislative and enforcement headwinds, no matter the industry, but the impacts are no doubt doubled or heightened in the healthcare sphere, where many employers advance professional educational and training expenses conditioned on continued employment of the physician or professional. So the enforceability of traps raises some special issues as similar to non-competes, as they are seen as limiting employee mobility. Because enforcing a trap requires the employer to recoup money from employees, sometimes accomplished by deducting from their final pay, traps may also create other risks for wage and hour violations. Even though traps are generally viewed more favorably than pure non-competes, they do not per se prevent the employee from working for a competitor in that regard, but some states have begun to regulate them to protect what they see as um, adverse impacts for employees and invading the right for employees to have that mobility. So some significant examples, obviously California is top of mind. California prohibits employers from including employee promissory notes that require workers to pay debts, fees, or penalties if their employment terminates. Essentially, they ban traps. The law makes the prohibited agreements void under California Business Professions Code Section 16600 and imposes a civil penalty on employers of at least $5,000 per worker, in addition to giving workers the ability to seek actual damages, attorney's fees, and injunctive relief. The law does create limited exceptions, such as loan repayment assistance or forgiveness programs that are provided by a government agency, tuition repayment agreements for a transferable credential that meets specified requirements under the statute, and contracts related to certain apprenticeship programs. Similarly, sign-on bonuses or other specific job performance retention bonuses are exempt from the trap ban. And more recently, New York's trapped at work law, it will be going into effect in December of this year, mid-December. It will ban the use of employee promissory notes, making limited exceptions for, again, reimbursement of transferable credentials, non-educational incentive pay not tied to performance, the sale and lease of property to an employee, and sabbatical leave for educators, among other limited exceptions. Employers in New York that violate the law by requiring their employees to enter into trap agreements will be subject to fines of between $1,000 and $5,000 for each violation. There is, however, no private right of action. Employees may recover attorney's fees if they seek an enforcement through a state agency. In addition to these laws, not only New York and California, Connecticut also has a ban with limited exceptions. On the enforcement side, several state attorneys general are actively targeting healthcare employers for the use of trap agreements. Notably, the attorney generals in Nevada, California, and Colorado recently announced, after a years-long investigation, that a large healthcare corporation and its staffing agency had agreed to pay a total of $2.9 million in penalties to settle allegations that they unlawfully required entry-level nurses to repay the cost of mandatory training programs if they did not remain employed with the entities for 2 years. Similarly, the New York Attorney General recently recovered over $600,000 for foreign-born nurses subject to contracts with termination penalties of up to $20,000. In that instance, the OAG found that since 2020, 2 staffing companies had collected this termination penalty from roughly 71 nurses, many of whom had resigned due to significant safety concerns and concerns regarding understaffing and inadequate patient care. And working mandatory double shifts and going weeks without a day off. As a condition of the settlement, the staffing companies will be required to forgive the outstanding debt of the former employees and remove the trap provisions from their contracts. We've also seen a recent settlement in DC where the AG settled with a university hospital over traps imposed on newly licensed nurses. Similar to the in New York AG investigation, these nurses were required to repay training costs of up to $7,500 if they resigned prior to a 2-year commitment. And in that case, the hospital went so far as to enforce the provision through an unlawful deduction from the nurse's final paychecks, thereby highlighting another issue often found with these trap repayment agreements is that you have to be cognizant that many states have final paycheck laws that prohibit the deduction for things such as training tools and other costs and expenses that are not subject to an authorization from the employee. And finally, in this area, and similar but not exactly the same, federal courts have recently allowed several indentured servitude class actions to proceed based on trap agreements and staffing companies using those to impose visa cost repayment obligations. So this is within David's sphere, but it overlaps in that sometimes we'll see these traps used to recover visa fees that are not recoverable under the law. So, for instance, the Tennessee District Court recently declined to dismiss a class action brought by Filipino nurses against a long-term care provider and a foreign nurse recruiter, alleging they were forced to sign contracts amounting to indentured servitude by requiring them to repay certain expenses if they did not remain employed for a defined period of time. We've seen cases survive some dismissal in Southern District of Ohio, where two healthcare companies, agreed to pay $1 million to end a proposed FLSA class and collective action, alleging indentured servitude, again, by a group of Filipino nurses. So the action item for your teams, you need to audit every existing non-compete and training repayment agreement for compliance with the laws of the states where you operate, with particular focus on the jurisdictions of California, New York, Nevada, Colorado, and Connecticut that have moved to ban or severely limit trap agreements. In addition, you need to be sure that your trap agreements comply with immigration laws and rules, and then you're not attempting to recover visa expenses from employees that are not recoverable under the immigration laws.
Yeah,
did you want to say something
about
to
that? On the immigration side of that, there's visa, the most significant visa there is what's known as an H-1B, which is the standard professional visa, and there are required wages. So what's going on is that if you require an employee to pay what's considered a business expense, whether it's attorney's fees or something like that, you're taking an employee below the required wage. And that's what's going on logically with the trap agreements. And that can lead, there are cases out there that employers have been significantly fined for violating the Department of Labor prevailing wage provisions when it comes to these visa cases. So it's an area of to tread very lightly and be very careful about compliance.
Thank you.
Yeah.
And of course, traps move us right into other wage and hour risks that we see. Some evergreen issues here continuing to plague healthcare industry employers. So certainly staffing shortages have been the defining challenge in healthcare operations for the past several years, since COVID and before. And they've, recently ignited a set of wage and hour risks that are now materializing as significant litigation and settlements. Of course, one of those issues has always been and continues to be time rounding. Several large health systems have continued to face lawsuits alleging that their automatic time clock rounding policies systemically shortchange their workers. Recent settlement of $1.56 million is a good example. It involved both rounding practice combined with an automatic meal break deduction that resulted in unpaid time. The second issue we see quite often coming up is the joint employer question. Many of our healthcare clients and entities do rely on staffing companies, and with good reason, and come to with the expectation that the staffing company will bear liability for its violations. Well, as we know, that's not always the case. And the more we rely on staffing agencies, the more likely a court or agency will argue that we're a joint employer, meaning you share liability for the wage and hour violations of the staffing company. It's going to be, there's a number of factors that courts will look at. There's common law tests, there's federal tests, and the DOL has recently announced a new joint employer standard that is not yet law, but is open for comment. Getting yourself acquainted with what those factors are and working to ensure that you are not held a joint employer is a compliance checklist item that remains. In particular, we saw the DOL revise its regulations interpreting the companionship services and live-in exemptions to exclude third-party employers such as home care agencies. This was a 2013 rule. Under this rule, third-party providers were required to pay overtime even where the caregiver is a live-in employee or caring for a family member. On April 14th, the Sixth Circuit rejected a challenge to the 2013 rule under the Loper-Bright analysis because Congress expressly delegated authority to the DOL to issue the regulations as to who and who is not exempt under the overtime laws. Now, since 2025, and the new administration has proposed a new rule to make these workers, again, exempt, and has said it is no longer actively enforcing the 2013 rule. However, the Sixth Circuit decision was recently reinforcing that although the DOL has proposed a new rule, it continues to enforce and will continue to enforce the existing rule to conduct that occurred prior to its announcement that the DOL is no longer going to be enforcing that rule. Another issue that continues to beleaguer healthcare employers is misclassification. Again, this overlaps with our concerns with joint employer liability and using staffing companies. In particular, when we rely on travel nurses or home health workers through a staffing agency, there's heightened scrutiny over those agreements and whether those individuals should be properly classified as employees versus independent contractors. For example, the Fourth Circuit recently upheld a $9 million judgment in 2025 against a medical staffing company for misclassifying nursing assistants and nurses as independent contractors. The concern here is that that liability can fall also on the client employer, the clients of these staffing agencies. Meanwhile, in Colorado, nurses are navigating a $14 million wage class settlement involving disputes over potential misleading opt-out campaigns regarding their unpaid wage action. Finally, of note, several states have moved to limit or to restrict mandatory overtime. That would include about 18 states, which would regulate mandatory overtime or ban it for certain professions. That's key here because, as we know, our nurses, due to staffing shortages, often end up working very long hours and can easily go over those mandatory overtime limits in those states. Finally, just a note about Nebraska. This is a new law that they've enacted, a Healthcare Staffing Agency Registration Act that imposes certain registration, credentialing, and record-keeping obligations on these staffing agencies, prohibits non-competes and conversion fees for healthcare workers hired permanently by the facilities that engage these staffing companies. The bottom line here with all of these issues is to review your timekeeping systems, your agency contracts, and your classification of every worker and how your staffing agencies are treating those workers, particularly travel and home health staff. Review these contracts not only for your standard provisions with indemnification and describing who has what duties and what's rights and obligations, but it's also important to speak with your providers, to ask them about their practices, to help you identify risks and potential issues that could come back to the client employer under a joint employer liability theory. Next, I want to talk a little bit about another emerging area of the law, turning now to workplace violence prevention. This is an issue that has moved from a best practice recommendation to a hard compliance obligation in several jurisdictions. Right here in Ohio, Governor DeWine has signed HB 452. It was signed in April 2025, requiring full implementation by last July, mandating that hospitals establish security plans developed with input from multidisciplinary teams that include their direct care employees and former patients. The rationale here is straightforward. Frontline workers and your patients have critical insights about where violence risks arise and what prevention strategies can actually work. Similarly, Texas has enacted SB 240, requiring hospitals and healthcare facilities not only to require them to create prevention plans, but to establish committees that keep the facilities compliant. Their law goes further than Ohio by mandating detailed monitoring of threats, incidents, and conducting investigations, and requiring facilities maintain accessible data demonstrating their compliance efforts and incident patterns to state regulators. Finally, Virginia similarly passed legislation in 2025 requiring hospitals to establish incident reporting. And Oregon, effective January 1st of this year, required healthcare employers to implement a full workforce violence prevention and protection program, including investigation procedures, collecting information, and reporting incidents. So the common theme here across all these states are that you must engage your frontline staff in planning, tracking, and documenting threats and incidents systematically, and be prepared to demonstrate compliance to the regulators. If you don't already have a workplace violence prevention committee with direct care worker representation, that's your immediate action item here. Even if the states where you operate do not specifically require such plans or reporting obligations, adopting these obligations voluntarily keeps employers compliant with OSHA's general duty clause and keeps the workplace safe from known and predictable dangers. Turning now to my next topic. So this is a kind of a catch-all for some other hot topics that we've seen arise that are affecting not only all employers, but in particular healthcare employers. Beyond the core topics we've covered, some other emerging areas include AI regulation and hiring. So several states, including Illinois and Colorado, have enacted laws that prohibit or restrict AI-driven hiring decisions, both in terms of discrimination effects, but also that employers, for instance, in Colorado, must be cognizant that high-risk AI systems require them to implement risk management policies, to complete impact assessments of how those AI decisions have affected the workplace and the demographics, and notify employees and applicants that they are using AI in those decisions. If your organization or your staffing or recruiting vendors are using AI in terms of recruiting or screening or even performance evaluations for their employees, you need to understand how state laws are regulating those and the impacts that those AI processes can have. Second, another growing area of the law is pay transparency. As of January 2026, 16 states plus the District of Columbia and multiple cities, including here in Cleveland and Toledo, municipalities in various states have enacted pay transparency laws. Most of these laws require employers to include a salary range in their job postings and maintain documentation related to their compensation decisions. Not only what is the range, but how did you arrive at that range? What factors did you consider? Did you look at the industry? Did you have you done a salary history of your workforce, et cetera? California recently made amendments and is a good example of this trend. So in California, as of 2026, not only do they require the good faith salary estimate, but they expanded the definition of the wages to include all forms of compensation that the individual receives, including bonuses and benefits. So if you or your vendors post positions in multiple states, You should be building pay transparency into your standard posting workflow and ensuring that your staffing agencies are doing the same. Another area that is continuing to expand is paid leave programs. Both Delaware and Minnesota have recently launched new comprehensive paid family and medical leave programs beginning in January of 2026. They join a host of other states, including California and Illinois, that require paid leave for their workers. This patchwork of state-earned sick leave and family leave laws have grown and impact, in particular, multi-state employers who need to ensure that their leave policies and systems can accommodate these varying requirements. Now I'm wrapping up, just going to give you some key takeaways for what to do next with this information. So first, going back to our physician and other allied health provider agreements, conducting a comprehensive audit of these agreements and your training repayment agreements across every state where you operate can give you insight into where your risks might be and where you might need separate templates or addendum to those agreements. The second, as always, reviewing your timekeeping systems and those of your staffing partners for rounding and auto deduction processes. Having a comprehensive time card correction system in place and making sure that your contracts appropriately address joint employer scenarios and who is indemnifying whom in terms of, when there are violations. Third, establishing and working on your workplace violence prevention programs. If you're in Ohio, Texas, Virginia, or Oregon, you already have specific statutory mandates, but even if your state hasn't enacted such legislation yet, getting ahead of it and complying with OSHA's general duty clause to create baseline obligations is advised. Fourth, on the emerging issues front, if your organization or recruiting partners are using those AI-powered tools I spoke briefly about, you need to inventory those tools now, assess them against the legal requirements, including risk assessment and notifying employees and candidates of their use. And of course, we want to make sure that our standardized pay transparency practices are adopted, not only in the states where they have enacted such legislation, but if we're posting nationally, making sure that those posts comply with the most restrictive state. And finally, reconciling, as always, your paid leave policies with the newest state programs and ensuring that your tracking remains compliant and your reporting obligations, including reporting on pay stubs, how much leave has been taken and how much is left. That's, for instance, in California, that you are complying with those obligations. That's all I have for my presentation. David, did you have any additional questions for me?
No, I think you covered it. I'm wondering if any of the folks who've been listening have questions, and we can answer those.
Yeah, I haven't seen any questions come up in the chat box. Scott, have you received any questions? No? Okay, well, given that there are no questions, if you think of anything after reviewing the presentation, feel free to email myself or David, and we can respond. We hope you found today's presentation informative and valuable. If you are not currently receiving invitations for our webinars, we encourage you to visit the Thompson Hine website and register for our mailing list under Publications tab on the website. Subscribing will ensure you are notified of upcoming events and other relevant publications from our team. Should you have any questions that we are unable to address during today's presentation, please reach out to your regular Thompson Hine attorney. Of course, you can also reach out to David or I. If you are not yet a Thompson Hine client, we welcome you to contact us directly to discuss how we can assist you. We appreciate your time and attention today. Enjoy the rest of your day and stay well. Thank you.